A judge has dismissed altogether the $400 million defamation lawsuit filed by director Justin Baldoni against Hollywood power couple Blake Lively and Ryan Reynolds.
Blake Lively posting that she felt, quote, the pain of a retaliatory lawsuit, including the manufactured shame that tried to break her, now celebrating the judge's ruling that she says defeated the suit.
What happens when a $400 million legal missile gets swatted out of the sky in a single swing? On June 9th, a New York federal judge vaporized Justin Baldoni's blockbuster lawsuit against Blake Lively, Ryan Reynolds, publicist Leslie Sloan, and the New York Times. Overnight, the director of It Ends With Us went from confident plaintiff to scrambling underdog, and the ruling may redefine how superstar feuds play out in the #MeToo era. But how did a feel-good romance film spiral into one of Hollywood's ugliest courtroom brawls? Stick around. By the end, you might rethink which side actually holds the power. Rewind to December 20th, 2024. Production on It Ends With Us had just wrapped. The floral print marketing blitz was in overdrive, and Blake Lively should have been celebrating another box office hit. Instead, she quietly filed a complaint with California's Civil Rights Department. In 23 pages, she accused director co-star Justin Baldoni of crude jokes, surprise kiss improvs, and retaliatory mood swings that, in her words, weaponized creative decisions into intimidation tactics. Lively also named Wayfarer executives Melissa Nathan and Jennifer Abel, billionaire financier Steve Sarowitz, and CEO Jamie Heath, claiming they ignored repeated pleas for on-set safeguards. SAG-AFTRA's safety team, normally invisible, suddenly had boots on the ground, but a private filing couldn't keep the storm contained. Within days, the New York Times posted leaked Slack chats in which a Wayfarer PR strategist floated a Barry Blake Twitter push, complete with burner account memes and whispered leaks to celebrity gossip blogs. Lively's camp seized on the expose, blasting it across socials. The hashtag #StandWithBlake trended for 72 hours. Industry fallout was swift. WME dropped Baldoni. Novelist It Ends With Us author Colleen Hoover publicly sided with Lively. And Intimacy Coordinator Guilds praised her courage to document everything. Cue the counterstrike that stunned even veteran entertainment lawyers. On January 16th, 2025, Baldoni unloaded a 179-page countersuit accusing Lively of civil extortion and claiming she threatened to tank the film's release unless he ceded creative control and apologized publicly. He pegged his damages at no less than $400 million. A number experts say signaled scorched earth strategy rather than a realistic valuation. Ryan Reynolds and Leslie Sloan were dragged in for allegedly echoing false misconduct claims, while a separate $250 million filing accused NYT of libel. For context, Wayfarer's entire 2024 operating revenue was estimated at $48 million. One entertainment lawyer quipped, Baldoni asked for 9 times his studio's value. Either he's swinging for the fences or knows he won't reach the plate. Yet the counterpunch carried an Achilles heel only a careful judge would expose. Fast forward to June 9th, 2025. Judge Judge Liman, famed for marathon opinions, released a 132-page masterclass in civil procedure judo. Point 1. Litigation privilege shields anything stated in a legal complaint. So, Lively's CRD allegations are untouchable. Point 2. Baldoni never showed the defendants acted with actual malice, the constitutional hurdle for defaming a public figure. Out emails, texts, or testimony, proving Reynolds or Sloan seriously doubted their statements, the defamation spine snapped. Only 2 claims survived on life support: interference with streaming distribution talks and breach of an implied non-disparagement covenant. But even those must be rewritten by June 23rd, or they disappear forever. Meanwhile, Team Lively popped virtual champagne. Minutes after Judge Liman's opinion hit Pacer, Blake Lively's lawyers, Ezra Hudson and Mike Gottlieb, blasted out a statement hailing a total victory and a complete vindication for their client and everyone Baldoni tried to bully: Ryan Reynolds, Leslie Sloan, and the New York Times. What the press release didn't say, but insiders confirm, is that Lively's side has already logged roughly $2.8 million in legal fees. Under California's new AB 933, a law designed to stop retaliation suits against harassment whistleblowers, a prevailing defendant can demand automatic fee shifting, punitive damages, and treble damages, 3 times every dollar spent fighting the case. If Hudson's crew files that motion once the last claims are gone, Baldoni's liability could rocket past $10 million before punitive damages are even tallied. Hudson hinted exactly that on deadline, promising to seek every remedy the legislature gave survivors, including treble and punitive damages. New York's Anti SLAPP statute offers a second bite. It makes fee awards mandatory and lets a judge add exemplary damages if a lawsuit was filed to silence protected speech. Judge Liman tabled those sanctions for now, but Lively's team plans to refile the minute Baldoni's revised complaint, due June 23rd, fails. The celebrations went public fast. Reynolds posted a 2-second gif of Deadpool blowing confetti, racking up 11 million views in 4 hours. Lively followed with an Instagram story of a single tulip emoji and the caption, "Bloom where you're planted," a nod to her film character, Lily Bloom. Fans propelled #StandWithBlake to #2 worldwide on X, peaking at 185,000 concurrent posts, and even surfacing on Chinese Weibo hot search lists, where Lively hasn't trended since A Simple Favor premiered. The New York Times, dragged into the suit for reporting on the CRD filing, circulated an internal memo calling the dismissal a good day for the First Amendment and gently shading rival networks that prefer to settle baseless claims. Media law professor Charlotte Tams called the ruling the strongest federal affirmation yet that AB 933's privilege and New York's Anti SLAPP have real teeth, warning that future plaintiffs should bring proof, not press releases. Across town, Baldoni's attorney Brian Friedman blasted the victory lap, insisting Lively is terrified of the truth and vowing to depose her before month's end. Yet stone-faced silence came from Wayfarer's financier Steve Sarowitz. Insiders whisper private equity backers are already demanding a litigation cost cap clause if the case drags on. In the court of public opinion, though, Lively clearly owned the narrative. Late-night host Amber Chang devoted an entire opening monologue to the $400 million lawsuit that couldn't, courtesy of a tulip and a gif. While corporate HR blogs dissected the opinion as required reading for talent relations teams. But the chessboard isn't cleared. One bold move remains before time runs out. Sources say Baldoni will lean on 4 alleged deals he claims vanished after Lively's harassment narrative surfaced. A Netflix international window, a Hulu first look for TV spin-offs, a China co-financing pact with Bona Film Group, and an Emirates Airlines in-flight exclusivity package. Legal strategists doubt the contracts even reached signature stage, and Judge Liman signposted little wiggle room, hinting a lack of hard paperwork will doom the rewrite. Still, Baldoni's billionaire backer, Steve Sarowitz, reportedly greenlit any spend necessary to salvage reputation, meaning another epic court brief could drop hours before the deadline. Celebrity cameos have already turned the case into a social media circus. By late spring 2025, the lawsuit had mutated into a digital cage match, one that sucked in A-listers, sports heroes, and even Marvel Studios. First came the Taylor Swift subpoena. In April, Baldoni's lawyers demanded every text Lively had ever exchanged with the pop icon, hinting that Swift's friendship tweets were orchestrated defamation. Swift's camp blasted the move as tabloid clickbait, and by May 22nd, the subpoena was formally withdrawn. A federal magistrate noting it served no legitimate evidentiary purpose. The retreat fueled a fresh surge of #StandWithBlake posts. And in an unexpected twist, Kansas City Chiefs tight end Travis Kelce quietly unfollowed Ryan Reynolds on Instagram the same week, sparking think pieces on whether celebrity litigation was fracturing NFL Hollywood bromances. Then Marvel itself entered the fray. Baldoni sought Deadpool and Wolverine emails, alleging Reynolds slipped inside jokes about the lawsuit into the marketing. Judge Louis Lyman nixed the subpoena and granted Marvel a protective order, writing that the request borders on harassment. The denial underscored a pattern. Every attempt to weaponize star power was boomeranging back at Baldoni. Meanwhile, Hugh Jackman posted a #FriendshipGoalsReel, reel, reaffirming support for Lively and Reynolds and racking up 4 million likes in 24 hours. Wayfarer's PR duo, Melissa Nathan and Jennifer Abel, fired back with a midnight press blast accusing Jackman of performative virtue, but sentiment analysis dashboards showed their statement sank beneath 70,000 negative tweets in 2 hours, a phenomenon brand safety firm Sprawl Analytics labeled flash rejection, where influencer-led counterspeech overwhelms corporate spin. The numbers got brutal. According to a Vox deep dive on the feud's social footprint, Wayfarer-friendly hashtags averaged 15% human engagement versus 85% bot-like traffic, fueling allegations that Baldoni's crisis team was seeding disinformation. Graph clusters revealed 1,200 near-identical accounts posting Blake lied memes every 6 minutes. X, formerly Twitter, suspended 380 for coordinated inauthentic behavior, while Meta flagged a further 500 Instagram handles, neutering Wayfarer's narrative machine overnight. Behind the curtain, both camps were running 24-hour command centers. Lively's partnered with Dataminer to auto-surface defamatory content for takedowns, Baldoni's with Reputation Guard to boost coverage of his philanthropy videos. Yet, engagement stats told a stark tale. By June 1st, positive sentiment for Lively sat at 68%, Reynolds at 72%, Baldoni languished below 34%. Even mainstream outlets joined the content arms race. Forbes live-blogged influencer defections, while ABC News aired a segment titled When PR Wars Backfire, featuring crisis management guru Judy Smith, who warned that manufactured outrage is detectable at scale, and juries scroll too. With Marvel shielded, Swift off the witness list, and social media bots imploding, Baldoni's legal team faced a dilemma: double down on subpoenas or retreat before the algorithm turned his reputation radioactive. The public relations theater proved a preview of trial strategy, because if 12 jurors can Google a hashtag, controlling the narrative outside the courthouse may prove just as decisive as any ruling inside it. All these fireworks lead to a single date carved in courthouse granite. Even with his megasuit gutted, Justin Baldoni still has multiple chess moves before the curtain rises on March 9, 2026. Interlocutory appeal. He could ask the Second Circuit to revive the defamation and extortion counts Judge Liman dismissed. Success is rare. Fewer than 10% of such appeals win, but a reversal would put the nuclear warheads back on the board and give Baldoni fresh leverage in settlement talks. Early summary judgment gambit. For the 2 contract interference claims Judge Liman left alive, Baldoni can file a targeted summary judgment motion after core discovery closes this winter. If he proves Lively's statements directly torpedoed specific Netflix, Hulu, Bonafilm, or Emirates deals, he could narrow the trial to damages only and flip the optics from scorched earth plaintiff to wronged entrepreneur. Settlement mediation track. Quietly, Baldoni's team has floated a high-low bracket to Lively's lawyers, a sealed apology in exchange for dropping punitive damage demands. If either side decides the reputational risk outweighs a courtroom win, a confidential deal could still end the story before opening statements. Insurance and indemnification. Wayfarer's EPLI, Employment Practices Liability Insurance. Carrier has reserved rights but not denied coverage. Baldoni can pressure the insurer to fund defense fees, expert witnesses, and potential verdicts. Critical, because a fully financed war chest keeps Lively's fee-shifting threat from bleeding him dry. Discovery, shock, and awe. Expect an avalanche of subpoenas, deleted Slack threads, draft intimacy coordinator reports, Reynolds Sloan text chains, even iCloud backups from NYT reporters. Baldoni's goal is to unearth anything showing the defendants knew or should have known his innocence, bolstering malice on appeal and poisoning the jury pool with doubt. In Liman firewalls, Baldoni's counsel will seek to block Me Too hashtags, Barry Blake memes, and Taylor Swift-adjacent gossip from evidence, arguing undue prejudice. If the judge agrees, Lively's narrative tightens, and Baldoni avoids a trial that feels like a referendum on Hollywood morality rather than contract harm. PR rehabilitation. Reputation consultants have mapped a Hero Dad rebrand, charity live streams, behind-the-scenes vlogs about mental health advocacy, and a July 2025 TED Talk on creative conflict as catalyst. The aim? Humanize Baldoni for potential jurors and sponsors who will see the clips long before voir dire. Last-minute venue shift. A long shot, but not impossible. Argue that non-stop New York tabloid coverage makes an impartial jury impossible, petitioning to move the trial to California, where the underlying CRD complaint originated. Even if denied, the motion preserves another appellate issue. Legal scholars call this the choose-your-own-ending phase. One misstep, and Baldoni walks into court as a pariah, a strategic hit on appeal, or an evidentiary win. And he could force Lively to settle, or at least enter trial on shakier ground. The stakes are bigger than damages. The verdict could decide whether future harassment countersuits are doomed bluffs or viable counteroffensives. Was this a righteous pushback against defamation, or an expensive gambit to silence a whistleblower? Judge Liman's ruling hints the latter, but Baldoni has until June 23rd to rewrite history. One thing's certain: When reputations, billionaire backers, and the legacy of #MeToo collide, the first casualty is the tidy rom-com ending. So, drop your verdict below. Is Baldoni fighting for justice or grasping at straws? And smash that subscribe button because the next unfollow, the next leaked Slack chat, or the next cryptic lyric could flip this script all over again.